is a little bit switched around, but we have a group of medical and law students who will be talking to us about their perspective on enhancing / restoring professionalism in medicine. They are, you'll tell them about the health advocacy organization. Are you planning to tell them anything about that or how you got here? Not to law school or so I teach a course called Healthcare Controversies for law and medical and other health professional students. And I raised the topic of this conference with them at the beginning of the semester and invited them to weigh in on what they thought were the impediments to physicians being more having greater ability to have their fidelity to their patients. And if once identifying the problem, solutions, and we talked about it in class. And then I came back to them and I said, why don't you, if you'd like, get together, work together, come up with a presentation to the conference. And without more, here we are.
Hello, and thank you for joining us. We are a group of graduate students, like Professor Melman said, from CASE, and we would love to speak to you about the financial burdens that med school students face and how that affects the professionalism in the future physician workforce. Just a disclosure to learners, we have no planner, faculty, or staff from this educational program that has any relevant financial relationships within eligible companies. And we will now introduce ourselves briefly.
Hi, I'm Melissa, and I'm a med student and a law student.
Hi, my name is Anna, and I'm a second year PhD student in bioethics.
Danielle, I'm a medical student.
My name is Ellen, I'm a first year medical student.
I'm Kiana, I'm also a medical student.
And I am Gabriella, I'm also a medical student.
I am Lakshmi, I'm also a medical student. My name is Megan, and I am a law student.
Awesome. So we're going to start just by giving a brief overview of what our talk is going to contain today. So we're going to first start by giving you just the current landscape of student debt, particularly as it relates to medical school. And then we're going to move on and talk a little bit more about how we got here and how the debt that, as you'll see, is really high, how it became so high and how it's continuing to decline. Once we've done that, we'll talk a little bit about the impact that debt has on medical students and early career physicians. Once we've had a chance to do that, we'll talk a little bit about the impact of student debt, specifically on professionalism, as we're here at this conference for that purpose. And then we'll give you what we've come up with as some potential solutions to address this problem, as well as some additional considerations to think about. And then we will welcome questions or comments from all of you as experts as well.
So to begin, how much debt do medical students incur during their education? So the average medical school graduate has about 6 times the amount of debt as the average college graduate. And medical school graduates, about 43% of them have educational debt from their pre-medical education. So the grand total of debt that medical school graduates have on average is $240,000. I know Dr. He said that it was close to 300, and that is the trend currently. So the cost of tuition is rising every year, as well as the educational debt burden. So the average medical school graduate will have over $300,000 of debt by 2024 if we follow current trends. So is this the next slide? Okay. So this astronomical amount of debt that students incur during their medical education disproportionately affects students who are historically underrepresented in medicine. The majority of students that have debt that exceeds $200,000 are students that have Perkins or disadvantaged student loans. The prospect of taking on so much debt also deters disadvantaged students from applying to medical school in the first place. A survey conducted by the American Association of Medical Colleges showed that the cost of attendance was the primary barrier for Black, Hispanic, and Native American students from applying to medical school who were apparently qualified in their education. Additionally, the number of medical students whose families come from the lowest 40% of household incomes has been steadily declining from about 27% of medical students 50 years ago to only 10% in 2004.
So how did we get here? As you can see on the next slide, there have been climbing amounts of debt. The average medical student indebtedness has increased over time at a rate higher than that of the Consumer Price Index and at a rate higher than the rate of increase of average physician salaries. So by 1984, financing medical education had already become loan dependent, with over 86% of students graduating in debt. We're going to take a look at the forces that led to this shift towards high levels of loan debt, which have continued to rise rapidly over time. So currently, the current mechanisms for student educational financing may not be able to withstand the debt levels once a certain ceiling has been reached, which Gabby has already mentioned as with the trends increasing. So currently, nearly 25% of graduates owe over $200,000 and nearly 10% owe over $250,000. So that exceeds federal borrowing caps. So in terms of the primary forces that have caused this increase, one study proposed, once looking at the history of medical student debt, that there are two expanded missions of the medical college that cause this increase. The first is the research university model. A research university is an institution which integrates teaching and research, establishing academic inquiry as a primary mission. That mission often requires state-of-the-art research facilities. And in essence, these federal initiatives helped academic medicine to expand its role and capacity, but it didn't enable long-term financial solutions. And so as medical education becomes more complex, more expensive, more technological, a lot of that cost burden has been falling onto the student. So in addition to the research university mission, another expanded mission of the medical school is the clinical mission of academic medical centers. As clinical education became more of a part of the medical school education, that increased the budget of medical schools. So currently there are no standards for cost of medical school attendance, and these can vary dramatically between schools of the same locality, and they also vary dramatically between region of the US. There's no consensus on what the true cost of educating a medical student is, so that limits the accountability to students in society for these costs. So what we're basically saying with this historical lens is that if medical school education, the cost of it continues to be tightly linked to the research and clinical missions of academic medical centers, then you're going to continue to see this explosive rise in the cost of medical tuition, and it's unclear whether those cost burdens should fall to the student.
All right, so now that we have some background on the debt statistics and how we got here, I'm going to talk a little bit about the burden of debt on medical students and early career physicians. So first off, the burden of debt is not evenly distributed, and there is a gap in the debt burden across races and ethnicities, with 91% of Black medical students graduating with debt, 84% of Hispanic medical students, 75% of white medical students, and 61% of Asian medical students. So clearly there is a gap in the amount of debt that different students are taking on after medicine or during medical school. Next slide, please. We can also see how debt is associated with academic performance and perhaps influences specialty choice. So in academic performance, there were systematic reviews that noted a negative relationship between debt and academic performance. And additionally, there was a study that found scores on an internal medicine training exam decreased as debt increased. Additionally, in regard to specialty choice, there was a longitudinal study that took place looking at 5,000 US medical students from 1992 to 2012, and they found that anticipated debt influenced specialty choice according to projected income. Additionally, there was a survey administered to about 800 students at 6 institutions, and they found that the percentage of students that indicated that projected income influenced specialty choice increased while comparing first and second year students to third and fourth year students. Furthermore, the burden of debt is also associated with various components of mental health, physician burnout, and quality of life. In terms of mental health, higher debts are associated with higher levels of self-reported stress. One study found that greater than $50,000 in debt for medical graduates is associated with increased risk for alcohol abuse and dependence. And that was also a study looking at medical students. And another study found that higher debt burden was associated with emotional exhaustion and depersonalization. Looking at quality of life, one study found that greater debt was associated with lower quality of life scores. And regarding physician burnout, a study found that residents with more than $200,000 in debt were associated with higher degrees of burnout compared to students without debt.
So the impacts of debt go beyond like the individuals that have it and also reflect on professionalism in medicine in general. So just briefly before we talk about that, we want to talk about how we think about professionalism in medicine. So we think about that as the ability to advocate for patients and our peers, the ability to think about the community that one lives in and understand that this learning is like a lifelong process. It's promoting diversity in medicine, it's putting people over profits, it's upholding ethical values, it's upholding a commitment to patient care. It's having this fulfillment in life and career, and it's fostering medical education. So by having all of these high debts, there is this detraction from professionalism. The first way that we see this is that less people might choose primary care and specialty that they want because of these high debt burdens. Second, we can also see a diverse physician workplace in all workforce in all specialties, especially if certain people have higher debt burdens and that affects the sort of specialty that they choose. There's also the impacts of lack of diversity in medical education. So in general, medical educators make less money in general. So like people who want to go into that profession and go into teaching might not be able to do so if they have high debt burden. And then as a result, there's also less time spent mentoring, teaching, staying updated on research, and performing the sort of advocacy work that we expect as from physicians as a profession.
So another important way to contextualize this burden of financial debt has to do with the reason why many of us entered the field to begin with, and that is the ability to treat patients and their outcomes. And so some of the effects of physician burnout specifically, which Ellen talked about, have to do with increased rates of physician and staff turnover, and that especially has burdens patient populations that are underserved. It leads to an increased rates of medical error and malpractice, which affects 250,000 patients that die because of medical error in the United States per year. It leads to increased rates of depersonalization, which Ellen has also mentioned. And just to clarify, that's the feeling of treating patients as problems that need solutions or conditions that need treatments, as opposed to putting them as people first. And then suboptimal physician-patient communication, which includes things like decreased rapport building and a decrease in skills such as providing patients with a full understanding of their condition and available treatments. And so this is really important just because we want to be able to enable physicians, future ones like ourselves too, to best treat their patients. And so understanding the impact that this has on patient outcomes is really important to solving financial debt.
Okay, wonderful. So we didn't just come here to give you a problem. We, like many of you, have been brainstorming solutions to this potential problem as well. So in thinking about where we can go from here, these are some of the solutions that we've talked about as a group and some that we think are maybe some of the best ones that we talked about among many. So the first is that of need-based reduced tuition. So the objective of this would be to increase accessibility to medical school and furthermore ensure that debt is not a barrier to any person in pursuing medical school. This is also a way to target those that are in need in a really focused way. So it's going to go to that population, one, that maybe doesn't go to medical school because of the impact that debt might have on them, or conversely, the population that does go to medical school and is faced with more debt than maybe the average student is during this current time. The second solution we talked about is that of a uniform tuition cap. So this would address the continually rising cost of medical education. We think this is far more beneficial than tuition freezes, which some of you might be familiar with as the current practice at a lot of schools, where when you enter medical school, the school freezes the tuition, so you pay the same amount as a first-year student that you would pay as a fourth-year student. The problem with that is that it still allows medical schools to continually increase this climb in tuition over time. It doesn't keep them at that maximum level of what is, effective to charge for medical education. Our third proposed solution, which might sound a little bit far-reaching, is that of reduced third and fourth-year tuition. We talked about this as a means of compensation for medical students who are providing a lot of value in clinical settings as third and fourth year medical students. Certainly, they're still there in a lot of contexts to learn, but they are also contributing to patient care and are a part of the care team from that first day they step foot in the hospital or other clinical setting. And then the final solution that we've talked about some that actually is the starting point for this presentation, because we initially said, oh, well, let's just go in there and tell them that medical tuition should be free. And then we started to walk that back and realize that there are a lot of barriers in the way for that. We think it could be something that's feasible one day to potentially make medical school tuition free. Just an interesting statistic for you, making medical school free for all students would only be about 1,000th of what our country spends annually on medical school or on medicine and healthcare in general. So certainly something we're considering down the line, but we think there are probably a couple of steps between here and there.
Okay, so now that we have our proposal, we did want to address some of our anticipated, I guess, counter arguments or considerations. So the first thing that we anticipated being a question in response to this proposal is, now that we've reduced or capped tuition, how are we going to supplement that lost funding? We have a couple options for this. The first option, and this is a little bit difficult because, as we mentioned earlier, there isn't full transparency about what exactly, how exactly med schools are using tuition. So I think research would be needed to, I guess, solidify whether this would be a possibility. But in general, if we reduce tuition by 10-20% for students, would it be possible for med schools to operate without supplementing that funding or supplementing that lost tuition? Unsure, but that was one of our options. Option number two, potentially the most obvious, would be public funding. And we thought of this from a national federal level, but also potentially more of a local level, such as the city of Cleveland contributing to Case Med School. A third option, and this one I think relates mostly to our third and fourth year reduced tuition idea, because they are involved in clinical rotations at local hospitals generally, that the nonprofit hospital systems or institutions could contribute to the school, the med school, in order for them to be able to reduce tuition for third and fourth year students. And that could be seen as a part of the nonprofit's community involvement per se. So that was a third option. Our next consideration we had was that debt forgiveness programs already exist. So why can't, concerned med students just take advantage of one of those? Because there are quite a few. And this is true, but I guess from our research, we had concerns about how effective these programs actually are at mitigating the concerns we presented earlier regarding like the burden of debt on med students and young physicians. So I went into some research on this, and before I talk about it specifically, I wanted to note, similar to what we talked about earlier, there was, I guess, a lack of especially in the federal programs, I was surprised not to be able to find specific effectiveness studies on, I guess, how much debt is being reduced by these programs. But there were some, I guess, more focused studies that I found that sort of get to this point. So the first one, I want to talk about state programs first. The Pathman study looked at several state financial support for service programs. And I think from this, there were two big takeaways. The first was that these state programs generally are meant to entice graduates to train in rural or community-based settings. So they're trying to get med students and residents to need-based areas. And this study evaluated many different types of programs, but by far the loan repayment and the direct financial incentive programs were much more popular and effective than a scholarship model, because the scholarship models tended to be more obligatory, and the participants in those programs had to decide much early on, and they were, I guess, more committed with potential penalties to leaving that program, whereas the loan repayment programs and the direct financial incentives provided outs, so the people might lose their loan repayment process, but they were able to, if they weren't satisfied in their practice at that location, they could leave and practice elsewhere. So in combination with that study, with the idea that most of these state programs occur in rural settings, the Blanchard study does not necessarily evaluate the debt forgiveness programs, but it looks generally at where med school graduates tend to end up. And the overwhelming majority of graduates actually train in private nonprofit hospital systems. So from this research, it doesn't seem, especially in even in primary care and internal medicine specialties. So just given this data, it seems like there's some sort of deterrent that many graduates are not electing to take advantage of these debt forgiveness programs. And I'll touch on that in a bit. Moving to the federal programs, there's several, but I looked at potentially the largest one, which is the Public Service Loan Forgiveness Program, and that's available to a lot of different graduates, but for med students in particular, and it's available to anyone working in a nonprofit organization. So this program just generally the forgiveness only happens after 10 years of payments, which is to me a limitation in and of itself. So a med school graduate is still paying their loans for 10 years, which obviously can amount to a lot of money. And then in addition to this, the Friedman study discussed the financial impact that med school graduates would have to take on if the proposed cap on this program were to go through. Luckily, so off of this study, that was another limitation I kind of picked up as well. Federal programs are subject to, for lack of a better word, the administration that's controlling them. So for example, in the Trump administration, there was a proposed cap on this program, and they even proposed eliminating it entirely. Whereas in the Biden administration has been trying to expand it. So for these reasons, I think it's very difficult for med students to rely on a federal program like this. And I don't think that it's necessarily going to minimize those burdens associated with taking on the incurring debt over time. Basically, the takeaway here is that while there's a bunch of programs that exist that can potentially forgive debt, and obviously this presentation is addressing all of them, but from our research, it's a little bit unclear how effective these programs are at really addressing like what we've presented here as the main problem. And we think that there seems to be some sort of deterrent to med students entering a lot of these programs, potentially because they're located in rural settings, particularly when there are private organizations offering much higher paying salaries.
So looking at our third proposal on offering reduced tuition for third and fourth year med students, I think there are many arguments for and against this. And I think the main argument against is the fact that, med students have to be trained, and there's an argument that because of that, it creates a lot of inefficiencies and redundancy in patient care. So it's really more training than working. However, I think like the opposite can also be argued for why they do provide value and patient care, is that they have more time with patients, so we can be supportive of them. Sometimes we just need to lend an ear. And also we can make them feel more comfortable and at ease, help them open up. And we can perform, because we have more time, we can perform more detailed patient interviews, including on health disparities, help identify them, and even propose solutions. And also we can serve as clinical process extenders, so we can perform more like in-depth chart reviews, which I can think would be helpful. And also we can perform delegated tasks from like residents and attendings, such as like performing more frequent checkups on patients throughout the day. And I think also we can write patient visit notes, which can be co-signed by residents, can be helpful. And we can help educate and counsel patients as well, such as on the disease and treatments and whole clinical process in general. We can translate medical jargon or clarify medical jargon that's been used and help identify gaps in patient knowledge. And also counsel patients with regard to like motivational interviewing and using those skills that we learned in med school. Med students can also be utilized, I feel like, in other ways as too. I think there are more like innovative ways, such as being health coaches can be helpful, and performing research on like health systems and quality improvement projects. And also reduced tuition can relieve that stress. There's that burden of debt that can be very stressful to us med students. And it can really hinder our ability to focus on our education. And also another argument for us, in comparison to kind of other terminal degree programs, if you look at like PhD students and JD students, there are really more opportunities for them to get compensated in some ways. For instance, for law students, you know, whether it's through your summers or throughout the school years, if you work for a law firm, you can get a considerable amount of money for that. And PhD students, I think, as well, like if you're a TA. But I feel like those kind of opportunities to kind of offset that tuition are very limited, scant, if any. Especially since oftentimes med students only get one summer depending on the school. So in conclusion, really, while our proposal might be too late for all of us, a little bitterness in my voice, we hope to inspire the future generations of physicians to focus more on why we really went to med school in the first place, that idea of patient care, and less on that burden of debt.
Questions, comments from the audience? So Dr. Letterman.
So that was a great presentation, and just have a couple of things I want to either say or ask. The first is that you underestimate the value of having students on the medical services. It's not just the services that you provide, but it's also the environment that you enrich by being there and offering opportunities for education. And when it comes to the Socratic method, for example, who knows less than you do? I mean, it's fantastic to have students on the service. It really makes a huge difference in terms of the entire atmosphere. So don't underestimate that. My second point is a question, and that is there are now a number, and I don't even know how many there are, of medical schools that are tuition free. And so I imagine getting into those schools is exquisitely competitive for a variety of reasons. So do those schools, are their student bodies representative of the underrepresented in schools? How does that work out?
Yeah, so we did look into maybe possibly doing a case study on one of those schools, but I guess kind of the problems that we were facing is that a lot of them are either too new to like really have a good idea of their impact on medical education as a whole, or for example, at Case, we have the Cleveland Clinic Learner School of Medicine, which does have a good amount of diversity, just anecdotally speaking, but its focus is a little bit different than, you know, some of the arguments that we were bringing up. We are concerned primarily with like the lack of physicians and primary care, things like that. But learners focus primarily on training physician scientists. So the jury is still out.
Can you start? You guys the mic, so go ahead, Dr.
Got the
Silver.
mic so I get to ask questions. Okay. The good presentation. First thing I might point out to you is that it sounds a little self-serving. You're not going to get a whole lot of sympathy for a profession where your chances of winding up in the top 2% of the income distribution are very high. So the front end cost for something that pays off very handsomely for relative to the rest of society is not a real great sales pitch. Okay. The sales pitch that you should be making is getting the right medical resources in the right place. Okay, that's what you want. That's what society wants. They don't want to make you more successful or give you an easier entry into a high income profession. So I think that's the first sort of pitching of the thing that I think you need to think about. So the question is, if your goal is to try to get medical resources in the right place, where is that? You mentioned a couple that are obvious: primary care, certain locations, maybe things of that sort. And how do you do that? The targeting of those incentives is obviously part of it. So the rural and the Indian Health Service, the rural facilities, the underserved areas are obviously a place we've done that with some success, but not 100%. If you really want to have more primary care, then you target your incentive towards primary care. So people that go into primary care have quicker forgiveness of their loans, they get more subsidies, whatever you want to do, whatever mechanism you want to do. Secondly, because you're talking about a long-term horizon here. You don't immediately get rich right off the bat. You get rich over 10 years or 15 years. Spread the loan out for a long time so that the annual cost is not going to make you live in a hovel. So cut the annual cost down to a much larger thing. That means spreading it out over a long period of time. And maybe making the loan forgiveness not just at the end, but along the way. So that as you do more with primary care in an inner city FQHC, you get loan forgiven right then. So you stop making those payments for the intermediate period. You can do some things like that to do it. Third is payment in kind. One parallel that struck me while you're talking, most of the facilities you see around here, except the ones that have been built in the last 10 years, maybe 20 years, were built by a program called Hill-Burton. Hill-Burton provided loans, but mostly provided grants to hospitals to rebuild after World War II. And that's where most of our older facilities came from. The proviso was that those hospitals had to provide free care to the population at a specified level for a period of 20 years to, quote, pay off the loan. That's payment in kind. So to the extent that you do a payment in kind, the more that you work in a whatever targeted location or profession, the more that you get more forgiven. You're paying it back to society. And once you paid off that loan, then you can go off and make lots of money if you like. The last point I make is that don't be naive about medical school financing. It is incredibly complicated, and it is way more complicated than you appreciate at this point. Hospitals already do make substantial payments to medical schools to support them, very large, historically incredibly large numbers, for lots of reasons. It's not surprising that that VA facilities are always next to medical schools, because they get payment in kind. Part of the teaching comes from free teaching. I'm on the board of Metro Health. A third of the teaching goes on from Metro Health physicians for free. Metro Health is paying the bill, not the medical school, not the tuition. It's very complicated. And lastly, if you didn't have NIH grants and NIH overhead, the whole medical school establishment completely fall apart. It's completely dependent on that. Tuition is a small part of the whole thing. So that's why you can get away with cutting tuition down, doing the way that we've set tuition dollars has almost nothing to do with what it really costs. You know, it's a whole set of other finances that are much bigger than this. So don't get caught up with making assumptions about medical school. It being very simple. It's very complicated. And frankly, in my view, it's a house of cards. It's not really well done.
Not a question, obviously, but any response, by the way? If you have a response, please.
I think thanks for your points. There were many of them. So I think I only have a response to one that stood out to me, which is basically that as like a group with high earning potential, our cost of education should be like less relevant, I guess, publicly, or like it's I think the biggest point that we took away from this is that we'd like people with lower socioeconomic status and groups that are underrepresented in medicine to not face a barrier, and that over time the increase in cost has basically made this problem worse. Like we mentioned, basically like in 1971, 27% of families came from the lowest 2 quintiles, and now it's dropped to 15%. And then 2004, it's only 10%. I'm sure now it's even lower than that. And so our concern is that if debt forgiveness does offer some solace, I guess, psychologically, but it doesn't really help those students for whom, for example, federal loans are not going to add up to the tuition costs as we continue to increase them.
Make it bigger.
And I think basically our concern is just that as we see, the biggest burden is still cost for students that are underrepresented in medicine. And that's why one of our proposals was a need-based program. So that focuses on giving grants to those students for whom cost would be a burden.
Ladies, a wonderful presentation. I'm a graduate 30 years ago of Georgetown, at the time the most expensive medical school in the country. Don't know what it is now, might be Case. I also went to an expensive undergrad school, but upon my graduation from med school, I decided to join the Navy because I didn't want to pay. I knew what was going to happen. That being said, what looks like it's happening in the academic centers. I think what we could ask maybe to do, and when you go into politics, as the attorney among you will say, you have to give to get, right? And I think one thing that you might propose is some of those NIH grants, instead of going to overhead and all the nice new buildings the university is doing, that a higher percentage of it be applied to tuition for students. I think we can all agree on that. One of the other things that I think needs to be done is that we need to expand state medical schools, not private medical schools, but state medical schools. It just needs to be done. The private schools are just going to always have trouble keeping up, but the states need to be convinced to expand the opportunities for students. I think one of the other sad things that's developed is the gap year. I think it's many people just become scribes, and I really don't think that's a useful exercise. I think people need to be pushed into medical school, but the other end is the problem too. There's no GME. How many of your graduates now cannot find a spot after you're done with your medical school? This, I think, this is where it comes in with the politicians and getting into Washington, D.C. People need to, there needs to be a program to change the federal program to allow people to go right in after medical school and work in the underserved areas and immediately start taking away tuition. We need well-trained people to be in the Indian health clinics, the rural qualified medical clinics, the urban clinics. Those are the things that somebody needs to take, and it's going to be medical students that do it. It's not going to be us doctors. I can tell you after 30 years, I'm tired. And this is my hobby, is coming to advocate for physicians. This is what I do. I work 40 hours a week. The other 10 hours I'm advocating and doing different things for physicians. And so it's medical students who need to go to your congressman, find a sympathetic ear, and go to Washington, D.C. It's never going to happen any other way.
Let me throw in a few extra comments. For me, this is more a cultural issue than it is a detailed policy issue. This nation has, especially in the past 50 years, been reluctant to reward service. It thinks of marketplace as everything. The National Health Service Corps was founded in the early 70s when there was still more of a service approach, but for political reasons that I don't really know, it never expanded to the degree that it should have expanded. My son is a lawyer. He graduated law school about 8 years ago. He is in the public service, loan forgiveness. He's working in public service. He understands that the 10 years are very much worth it. The public service always pays less than the private service. And so, you know, he's happy with his career decisions, and the 10-year payoff is reasonable. So I think that, and this is complex and other people know a lot more about the policy details, but I think that ultimately this becomes a cultural issue. I think we have to push service over marketplace mentality. And if we do that and look at it in a longer time schedule, time frame, I think we can move in the direction we need to go to.
Congratulations on a job well done. I was glad to see the lawyers and the doctors working together, because that's what the conference is all about. I don't know whether your proposals will make it or not make it. I don't know if they're good or bad, but at the end of your conference, at this conference, really the question always is, what are you going to do next? And one of the things that you see with good ideas is they stop too soon. You should take your proposals, whatever they are, to both organized medicine and organized law in resolution fashion, and try to get some support for them, and then take them to the state level, and then keep pushing it until you're beaten or you prevail. That's the hard part, is now you got to go to the next step. You have, I don't know, the ideas are good. If they're good, they'll go. If they're no good, you'll get beaten at some point, but you got to take a shot. So go forward and do the next thing.
Thank you. Question, comment? Go ahead.
A comment. I have 43 years experience in working with people with student loans, and I'm aware of the problem. It's the biggest problem we have in the country right now. There's over $1 trillion owed in student loans. And I was around during the Vietnam War protests, and students on campuses, medical students, law students, undergraduate students, put an end to the war because they took steps to do it. And if you guys are really serious about doing something, you have a great presentation, but it needs to be communicated, as the doctor said, to the politicians. It's a political issue, and only the politicians can solve it. You have some great ideas there on what could be done, but you've got to, as Bob says, you've got to act on it. And by acting on it means you have to relay this information to politicians, to lobbying groups that have impact on politicians. For example, the car industry has lobbyists in Congress, and those lobbyists have some power. And if you're going to be paying student loans and you can't buy a car, that affects the car industry. If you can't buy a house, that affects the housing industry. And Congress will act when they become aware that the economy is affected by the quagmire of student loans. And the presentation you have, the information you have, for example, that people, I'm aware of the matching format, that you all are aware that people are going into urology, the other specialties, and not into opening up a general practice because they can't afford it. They've got to go for the highest paying because of their student loans. So the student loan issue impacts a lot of things. And inside your presentation, I thought it was fantastic. There are a lot of items there, but you have to, as Bob says, take some steps if you're serious about it. And not only you, but other schools. I'm sure there's other people, you're up there, and I'm sure there's other people at other universities, at other law schools, at other medical schools that have the same problem. And if you could work in unison, be activists, and that's what I think this conference is about, being an advocate, being an activist, taking action. And I just echo Bob's comments is don't stop here, keep going with it, and good luck.
And comment or no? And just to point out, the topic of tomorrow's conversation is where to go from here, how to not just have a conference and say, how do you do? So, keep those ideas in mind for tomorrow. We have a comment from a person remote.
So Fred has a question. I think he's going to come up on the screen. There he goes.
Yeah, hi Fred.
Well, in light of the last comment, I wanted to ask the panel in terms of their proposals, their analysis of the program, what positions, if at all, has AMSA taken?
Medical Student Association.
We do not know.
Which says something at least about how visible and vocal that position is if they've taken one. But that's a good question. Yeah.
I mean, for people it was asked in code in case others in the audience, AMSA is a American Medical Student Association.
And it's one of the topics that I hope we'll bring up tomorrow is how do we get these organized groups to carry forward some of the ideas if we agree, or the ones that we think are worth pursuing. And this could certainly be one of those. Where are the power centers? Where are the forces that can make change?
I want to make one more comment, respond. I just want to say I appreciate everyone's feedback. It's been really great to hear all your thoughts. I also wanted to say that I think what Dr. Frisoff mentioned about basically that this is a cultural problem, I think that's one of the big takeaway points that we hope you have from our presentation, which is that the cost of medical school is an underappreciated area of healthcare reform in our country.
All right. Well, thank you very much. So, our next, Dr. Batanti is going to return to the podium, so to speak, and present a further proposal. And then I know we had some time for discussion scheduled for this afternoon. I don't We may not end up with very much time for that, but we do have tomorrow morning. And I hope you'll all join us tomorrow to carry on the discussion. But after Dr. Batanti, I will be making some additional remarks. Can I talk from here?
Well, thank you. Thanks for hanging around to the bitter end. Not quite, not quite. Bitter end for me. And I always like talking at the beginning of the show because you can always sell yourself as Jimmy Durante. When you're at the end of the show, you got to be Frank Sinatra. It's a little bit tougher. Anyway, I want to go back and go revisit being on the square. Because I think that's what we're really talking about. Are you on the square as a physician to your patients and to your profession? That's really what we've been talking about. Well, to be on the square, you have to deliver on your promise. And we already talked about what your promise is. Your promise is deliver medically necessary care every time. And along with that, we've spoken about you live and die by your professional reputation. And even minor deficiencies on your promise can lead to the allegation that you're a chiseler. Well, I'm going to talk about Youngstown for a minute again, because I learned a lot when I lived there, and I think it teaches us a lot now. In Youngstown, there was one individual, Fats Alio. Now, Fats only weighed 134 pounds, so we obviously got that name as a nickname, which is typical of Italian guys. Everybody got a nickname. I don't know what that was all about, but over the course of four decades, at least 3 decades, they wrote 34 articles about him, all of them citing him as a gambler, bookmaker, blah, blah, blah. And they would had trials and on deposition, right on the record. He said, yeah, I'm a gambler. That's what I do. But they wrote one article about Fats Alio when they called him a chiseler. And this was the only article that he was upset about, because it went to the heart of his character. It was a very, very interesting story when that was told to me about what upset Fats Alio. Well, there's been plenty of written about a physician's reputation, and one of the best books I ever read really was by Dr. Kethel. It was written in 1903. The book has been derided by some modern authors that said it was really an etiquette book, but it's not. It talks about physician's reputation and what goes to the heart of it. A couple of quotes that I thought were really good. The public opinion is the Supreme Court, and that's the truth. If you have a strong reputation, you'll have a following. If you don't have a strong reputation, you won't. And professional reputation is a physician's chief capital. And the ambition to increase this by all legitimate means is not only fair, but commendable. We talked about it earlier this morning. Everybody's promise is deliver medically necessary care. We talked about what the definition is. Medically necessary care is reasonable and comports with community standard. It's the Sarché's a California Supreme Court case, Hughes an appellate case. I have to thank Dr. Hall once again for illuminating the organizing principle theme, which is if you don't have an organizing principle, you don't know where to start, you don't know where you're going. And mine now, and is going to be in all recommendations I may make, that the delivery of medically necessary care should be every time, on time, by the appropriate provider, and adequate reimbursement made to the provider to assure his or her availability to the next patient. We talked about if you don't deliver on your word, you've been gagged. That's a Youngstown term that you've been duped, you've been cheated. I wasn't going to do it, but I'm going to do it. I'm going to use my mother as a prop. My mother's here. She's 96. She has proven osteoporosis. She has a thoracic compression fracture. She's been on bone-sparing agents for 10 years. 5 years ago, the recommendation was made she get the same agent, and it was denied as medically not necessary. Now, how is that possible? I'm sure if I met that physician reviewer that did that, the first thing I would hear is, I'm Dr. So-and-so, and they'd have a coat on with a lot of embroidery, and I'd get to hear about his or her CV. I went to school here, there. I'm double board certified. I did studies. I lecture. The problem is that you just gagged my mother. If you gagged my mother, I'll bet you're gagging other people's mother. And you get away with it because you do it in private. And that's what we're going to talk about fixing. Well, the question, if somebody recommends medically necessary care and there's a opposite opinion, it's not medically necessary, who should decide who's wrong? Somebody's wrong. Should it be an administrative appeal? Should it be an independent review? Should it be civil litigation? Should it be class action litigation? What's it going to be? Professor Hall wrote about this years ago. I've hated to burden him all day with his own literature, but it was really quite good in that he said the one thing that it shouldn't be done is by civil litigation. And I agree with that completely, but maybe for different reasons. Number one, it only solves one person's problem at a time. The second thing is, for that one person to get that done is going to require an attorney who has an interest in medical necessity cases, and there's not many of them. Then beyond that, it's going to have to not be an ERISA claim, because there's going to be no money in an attorney taking an ERISA claim on a medical necessity allegation. So how are you going to solve this then? You're not going to do civil litigation. You're going to go through the appeals. If you go all the way through an independent medical review, you still have a 50% chance of not getting the recommendation. I think a case that came out in California last year is maybe portends a future resolution about how this determination is going to go and solve the problem of hiding behind the screen when you make a recommendation. In the case Bradley versus CVS Pharmacy, a physician sues a pharmacy for not filling his prescription. The court said, you know what, we could deal with this, but we're not going to deal with it. we're going to impose primary jurisdiction doctrine and send it to a administrative body that has special expertise in pharmacy and drugs and these kinds of issues, see what they say. And we're here to listen to the answer if you don't like it later on. But we're going to show judicial deference to administrative expertise. They cite Business and Profession Code section 733, and they send this case to the pharmacy board to be looked at. So what 733 Business and Profession Code say? It says no license shall obstruct a patient in obtaining a prescription drug or device that has been legally prescribed or ordered for that patient. A violation of this section constitutes unprofessional conduct by the licensor and shall be subject to disciplinary or administrative action by his or her licensing board. Unprofessional conduct. How about on the other side of the coin? Business and Profession Code 725 says repeated acts of clearly excessive prescribing, furnishing, dispensing, administering drugs or treatment, repeated acts of clearly excessive use of diagnostic procedures, repeated acts of use of diagnostic or treatment facilities determined by the standard of the community is unprofessional conduct for a physician and surgeon, dentist, podiatrist, psychologist, therapist, chiropractor, audiologist, speech pathologist. So it's one or the other. You were clearly prescribing more than is necessary by the community standard, or you were obstructing somebody. Either way, it's unprofessional conduct. So there it is. Somebody is going to be found to have committed unprofessional conduct. The medical board has special expertise in the standard of care. They do it all day long. They get referred cases by clients, and by patients, by agencies, by insurance companies, by government. Anybody can make a complaint to the medical board. A physician could file a complaint, or the court could refer and could use B&P 725 or 733 to find unprofessional conduct on one of the parties. When there's a finding of unprofessional conduct, it's going to harm a professional's reputation for eternity. There's no hiding. It's going to go on record. It's going to be there forever. There's going to be no CV, no lab coat, no resume, no title to wipe away the tarnish of unprofessional conduct. It can be found to be theoretically on the prescriber, the person denying care, supervisor, any license holder, and it will make all parties consider their decisions. No one is going to walk around their office, hospital, clinic, neighborhood, or country club with the same swag after a finding of unprofessional conduct. So we talked about this. I used Dr. Hall's recommendation to make your mark somewhere in your policy, and here we go again. This was from this morning's slide. And at the end here, in a couple places, we see an inadequate reimbursement causing medical necessary care not to be delivered. You can see by the appropriate provider. Somebody in the inner city goes to the hospital, they need a neurosurgeon, they need a thoracic surgeon. They say, well, we can't find one. You get one time, he's a Medi-Cal recipient, Medicaid, they pay the doctor so bad, he never wants to go back again. So that provider is lost for the next patient. So we have this, I made a mistake on the slide. It's an unwilling or unavailable provider. Unwilling are usually in the inner city, rural, chronically poor paying plans, including Medicaid. I consider them one of the worst actors in the medical system because of their lousy reimbursement and on holidays, weekends, and nights. So you have the denial of medically necessary care due to inadequate reimbursement, and the usual fall guy and scapegoat is the greedy doctor. You heard these young professionals. What do you want them to do now? Now you want to make them work for no money too? They're going to leave with a loaded debt. They got a life they want to lead too. Now you want them to work for nickels for what? Now what? What's the next burden you want to put on them? It's not right. It's not their obligation either. So I want to ask, is inadequate reimbursement a denial or delay of medically necessary care? I think it is. Let's face it, in America, you have to pay for talent to perform, period. You have to pay for it. You want LeBron James to play for the Cavaliers? You got to pay. You want him to play for the Lakers? You got to pay. It's the same in every arena. The first time I really saw differential pay in a bargained contract was I was involved with the electricians of San Diego County. And there was one group of electricians that got paid 400 or I don't know, 300, 400, 500% more than any other electrician. So I was asking some of the other electricians, what's this guy do? What kind of electrician work does he do? He says, oh, those guys work underwater. No kidding. You're going to get some differential pay to be an electrician underwater. So most hourly workers are very familiar with the concept of differential pay. You want the plumber to come to your house on weekends, guess what? You're paying a differential. You have some service that you want done Christmas Eve, guess what? There's a differential. You don't find that a problem, do you? No, of course not. It's just differential pay. And so far, the usual rhetoric about fixing the unavailable physician to work in urban areas, poorly paying areas, is let's go and get some students from an underserved community and bring him into school, and then he's going to go back to that community. Now, that sounds really nice, but you think that's really going to work? You're going to bring him into school, burden him with $300,000 of debt, and then tell him again, we want you to go back to that community and work for nothing. Come on. You know, that's not solving the problem. That's a fairy tale, and it's got to stop. So how do we solve the problem of an unavailable physician? We're going to have to pay for it. My recommendation is that all physicians be paid a differential for night, weekend, holiday work until the needs are met. And I say that for all payors, Medicaid, whoever. That's how you make people available to do a job that's necessary. You need them the most in the worst of times, holidays, weekends, nights. And most importantly, a differential pay by zip code until the need is met. It's very easy to delineate a bad neighborhood that has no doctors in it. Make that zip code lucrative enough to attract people. If you pay enough, you'll get Cedars-Sinai or some other group to go in there and meet the need. And so it's time to do it. And pay the piper to get people the care they need when they need it, on time, every time. Thank you.
Questions or comments for Dr. Battanti? Anybody? We will revisit some of these issues, I expect tomorrow. All right, if not, then let me be the proverbial tail end Charlie. And give a talk I was scheduled to give earlier, but I hope you'll bear with me. Tail end Charlies, by the way, the last plane in the formation, the ones that got shot down more than others, so be kind. I'll wait for my slides to come up. I've got a few slides. Okay, so what can the law do to strengthen the ability of physicians to fulfill their expectation of fidelity to their patients? So let's go back to that meeting in 1847 in Philadelphia. It was 1 year later, in 1848, that a court anywhere in the world first declared that physicians were fiduciaries for their patients. And it was as a direct result of the efforts that began at that meeting 1 year earlier. And originally, fiduciaries in the law were, that status was reserved for trustees of trusts. That goes back to the Middle Ages, actually, lawyers, members of the clergy. And now for the first time, a court said physicians are, as far as the law is concerned, fiduciaries for their patients. So one way you might think to encourage physicians to act, to fulfill their fidelity obligation to patients is to allow patients to sue them if they breach that duty. Hold them accountable, because this is not only now a professional duty, an ethical duty, but it's now a duty recognized in law. But the law has let patients down in this regard. There's an important Supreme Court case in 2000, Pegram versus Herdrich. Let me tell you briefly what happened. This was a case about an ERISA health plan. ERISA means an employer-provided plan. It was owned by physicians, this plan, and they received a bonus at the end of the year if the plan was profitable. And one way to improve the bottom line of the plan was to provide medical care only at facilities, hospitals, clinics, and so forth that were affiliated with the plan, because they didn't have to pay, extra costs to others. Now, one of the plan's owners was a Dr. Pegram, and he examined a patient named Herdrich and discovered a large inflamed mass in Herdrich's abdomen. But Dr. Pegram did not order an ultrasound diagnostic procedure at a local hospital, which they could have gotten right away, but instead decided that Herdrich would have to get it at a planned facility hospital, and that there was an 8-day delay to wait to get it there. And it was more than 50 miles away, by the way, from where the patient was. And before the 8 days were over, Herdrich's appendix ruptured and he contracted peritonitis. So he and his wife actually sued Dr. Pegram and others, alleging that that they committed medical malpractice by not giving him this diagnostic test in time, but most importantly, that they breached their fiduciary duty under ERISA, because ERISA makes certain people affiliated with an ERISA health plan fiduciaries under that plan. And the complaint that Herdrich's lawyer was making was that according to the attorney, the bonus feature created an incentive, quote, to make decisions in the physician's self-interest rather than the exclusive interests of plan participants. So what happened is a little complicated, but basically the Supreme Court opinion held that that the plan doctors weren't fiduciaries under some technical interpretation of the ERISA law. But the interesting thing about this case is something that the court added, and it's dicta, which means that it doesn't have precedential value for those of you lawyers. This is what they said. The defense of any HMO, health plan, to a charge of breach of fiduciary duty would be that its physician did not act out of financial interest, but for good medical reasons. The plausibility of which would require reference to standards of reasonable and customary medical practice in like circumstances. Thus, for all practical purposes, every claim of fiduciary breach by an HMO physician would boil down to a malpractice claim. In other words, patients cannot sue, complain about breaches of fiduciary duty stemming from a failure to provide medically necessary care, but only medical malpractice. And this dicta, in this case, was followed by a number of other courts denying patients the ability to hold physicians accountable for breaches of fiduciary duty in similar kinds of situations. Well, unfortunately, the Supreme Court is wrong, dead wrong. The law of medical malpractice, as law students may know, comes from the so-called common law, okay? The breach of fiduciary duty comes from a completely different realm of law, equity, handled traditionally by a completely different judicial system than the common law system that we're more familiar with now, which handles medical malpractice cases. The burden of proof in a breach of fiduciary duty case is completely different than the burden of proof in a malpractice case. In a malpractice case, the plaintiff, i.e. patient, has the burden to prove that the physician failed to provide reasonable care. In a breach of fiduciary duty case, the plaintiff has the burden of showing that the doctor had a conflict of interest. Once they show that, the burden shifts to the doctor to prove that whatever harm the patient suffered was not due to that conflict of interest. And if the physician can't meet that shifted burden, then the physician becomes liable for breach of fiduciary duty. And furthermore, the remedies are completely different. For medical malpractice, we heard before from Sarah about the kinds of compensation that you can get for for medical malpractice, a successful claim. For breach of fiduciary duty, the remedy is completely different. It's a constructive trust, which means in the PGRAM case, and this is what the plaintiff in PGRAM asked for, was that the plan beneficiaries, which were the employees of the company that had the ERISA plan, should have been given all of the profit that the plan had made, and the doctors, in other words, had made, because when they were, that could be attributed to actions based on that conflict of interest, the plan bonus features. And so that, to say that fiduciary breaches are the same as medical malpractice is just dead wrong. And interestingly, this was a unanimous decision by the Supreme Court of the United States. All those people came to the absolutely wrong result as a matter of law. Why did they do that? How could they get it so wrong? How many of you have heard of the case Moore versus the Regents of California? This is a seminal California case. Very, very briefly, a fellow, he happened to be from the state of Washington, had a cancer of the spleen. He went to UCLA Medical Center. They diagnosed him correctly. They said, we have to remove your cancerous spleen, which they did. And then they proceeded, the doctors that is, proceeded without telling him or asking him to commercialize the cells that they had removed from him, which in the old days were called surgical waste, and the patient had no concern about it. But here what they did was they commercialized it into an immortalized research cell line, which was worth, millions and millions, hundreds of millions of dollars. And the patient had to come back a couple times from Seattle to UCLA, ostensibly to follow up on his treatment, but actually it was also, or instead to make some, do some things that were necessary for the commercialization of the cell line. And he found out about it when he was walking down the hall at UCLA one day, and he saw a bunch of boxes that had his name on it, big container crates, and he wondered what the heck is that. And to make a long story short, he found out that they were, had taken his cells and were doing this. So He went to a friend of his was a law student who then went to a lawyer, who then went to a colleague of mine who had been a visiting professor here, Laurie Andrews, a famous health law professor at Chicago ITT Kent. And together they sued. They put together a lawsuit against the University of California and the Regents, UCLA. And what they sued for was conversion. And that's the fancy legal term for theft. They stole his cells. Okay, so somebody steals your car, okay, and if you seek redress from them for stealing your car, what do you get? You get your car back, right? So and if the thief has put in a very fancy stereo system, they don't have to give that back to you. They just give you back what they stole from you. So congratulations, successful plaintiff, or you get your cancerous spleen cells back. Have a nice day. When that case was, shortly after that case was decided, we had a colleague here at the law school named Peter Younger. He was a rather eccentric fellow. He had, before the law school moved into this building, it was over across the street, and you could hear him at the end of the day wandering around because you could bring your pets to school in those days, and he had 2 cats. One of them was good, one of them was evil. So you would hear him walking down the hall saying, good, evil. Anyway, when the Moore case was decided, he burst into my office. And he was spluttering in rage and incomprehension. And he said, why would they sue for conversion? Why would they sue for conversion? They should have sued for a constructive trust. And I said, what's that? Because I had never heard of it. I had no idea. And I went to Yale Law School. Okay. The problem was that I had not taken a course called remedies. And I didn't know about that was the proper remedy, that he should have sued for breach of fiduciary duty, which, by the way, the court in California corrected and said, don't sue for conversion, sue for breach of fiduciary duty for not getting his informed consent to the commercialization of his cell line, and sent the case back, and it was eventually settled, and that was that. When I heard this from Professor Younger, I called my esteemed colleague, Laurie Andrews, and I said to her, why didn't you sue for constructive trust? And guess what she said? What's that? So the Supreme Court of the United States didn't take remedies, and they didn't get it right. They didn't understand what should have been going on as a matter of law. So we got this sort of principle, albeit a dicta, that you can't sue for breach of fiduciary duty. You can only sue for medical malpractice. And this wasn't the only case that got it wrong, because there is no reported case anywhere in the United States in which a patient has successfully sued a physician for breach of fiduciary duty in the clinical context. Not one. There are a handful of cases where patients have sued successfully for breach of fiduciary duty for inappropriate sexual relations. There are a handful of cases where they've sued for truly outrageous taking advantage of patients financially. For example, physicians who say, I'll treat you if you make me the beneficiary of your estate. But other than that, cases where, like, this PGRAM case, where the patient shows, makes a colorable proffer of evidence that they were shortchanged because of the financial self-interest of the physician. None of them have resulted in payment to the patient. Okay, not by the judicial decision. So one, sort of suggestion to make, and how do we encourage physician professionalism, is put the fear of God into them. Get the courts to go back and take, make people take remedies classes, and make it more possible for patients to sue their physicians for breach of fiduciary duty. And that was kind of the approach that I took for many years, as Mark Hall knows, that was kind of, we needed to do that. But then I began to think, wouldn't it be better if we didn't think of physicians and patients as adversaries, as at odds, but rather thought that physicians really want to do the right thing by their patients, but there are systemic barriers to doing so. So how can we encourage and protect physicians when they are trying to do the right thing for patients? Okay. But that assumes that we know what the right thing to do for patients is in a specific case. So what about the Moore case that I just described, right? This immortalized cell line. The Supreme Court of California, the Supreme Court, said you should have, the doctors, what they failed to do, fulfill as a legal duty was getting the patient's informed consent to doing this with his cells, and that was a breach of fiduciary duty. So if the doctor had to get the patient's informed consent, think of the conversation, right? I'm going to take your cell lines and I'm going to try to immortalize them. Is that okay? Here's the risks to you, hardly any. Well, presumably the patient would want a piece of the action, right? Well, did the physicians, if the patient doesn't sort of volunteer that, do the physicians have to say, by the way, you should ask for a piece of the action? Is that what they have to do to fulfill their fiduciary duty? Would the physician have to tell the patient, and here's how much you should ask me for? Right? I mean, if you're acting in the patient's best interest, not your own, you might have to do that. If they didn't do that, would the physician didn't do that, would the patient have the ability to, the knowledge and the wherewithal to bargain successfully? Unlikely. Would the physician have to then advise the patient, oh, and by the way, you should consult an expert? And then what about, seriously ill patients, arguably competent to give their informed consent, but not in a particularly good position to engage in a bargaining process, or not able to afford to hire an expert, and so on. So what does the fiduciary obligation, this fidelity obligation, require in that kind of situation? We talked about the Wickline case a couple times today, right? The patient who was discharged after only 4 days. The doctors wanted her to stay in 8 days, but when the California Medicaid program said, no, we're only going to authorize 4, they discharged her after 4 days, and her leg was eventually amputated as a result. As I think Dr. Pedanti mentioned, that was a malpractice case where against Medi-Cal for denying medically necessary care, and all of the experts, including the patient's own experts, said, it would have been better had she stayed the extra 4 days in the hospital, but that wasn't medically necessary. It was within the reasonable standard of care to release her after only 4 days. So there was no suit against them for medical malpractice, and that was pretty much the end of the case. But the court went on, and by the way, there was no claim of breach of fiduciary duty in that case against the doctors or the health plan. But in famous dicta, the court went on to say, this is, by the way, that case, the court went on to say the physician who complies without protest with the limitations imposed by a third-party payer when his medical judgment dictates otherwise can't avoid his ultimate responsibility, can't point to the healthcare payer as the liability scapegoat when the consequences are his own determination. The payer in this case, as I said, was California Medicaid. So unlikely that if the doctor had protested, had said, wait a minute, you can't you can't say you're only going to pay for 4 days. The patient needs more, and badgered it or did whatever he could. It's unlikely Medi-Cal would have cut him off. I mean, refused to pay him for future care. Medicaid unlikely to retaliate against him. But what if it would have been a private health plan that wanted that patient out in 4 days, and the doctor then makes a concerted effort to fulfill his fiduciary duty, his duty of fidelity? Could the doctor suffer retaliation? Sure, right? Possibly even termination from the plan, right? No, you're no longer in the plan network because you've been such a pest and as advocating for your patient. And if the plan has a substantial share of the market, of the relevant patient market, being excluded from the plan could be harmful, if not fatal, to the physician's practice. So how do we protect physicians in these kinds of situations where they want to do the right thing, but they're afraid of being retaliated against by hospital employers, by health plans that they want to remain in the network of, have to remain in the network of? Well, one option that the law has come up with is to limit the financial incentives that are given to doctors to deny medically necessary care. The federal government has a limit on Medicare for Medicare Advantage Part C plans. The plan cannot be qualified under Medicare if it has to make no specific payment directly or indirectly for a physician to a physician or physician group as an inducement to reduce or limit medically necessary services. That's a federal law, so that's a step in the right direction. Many states have similar laws. So here's the law from Hawaii. A health carrier shall not offer an inducement to a provider that would encourage or otherwise motivate the provider not to provide medically necessary services. The red states all voted for Trump. No, they all have this law, but you can see there are a lot of gray states that don't. We could, so one of the things we need to do is to get all states to pass this law, this kind of law, so that these incentives, these just conflicting incentives aren't placed on doctors unreasonably. Another thing, every doctor's contract with, I think, a hospital employer and with a health plan has in it, their agreement has in it a provision that their relationship can be terminated without cause, without giving a reason, without having any recourse, without certainly having a recourse to judicial review. Termination without cause. They can be terminated for cause, but they can also be terminated without cause. 60 or 90 days notice, pack up your clinic, you're out of here. Interestingly, do you know who insisted on having termination without cause provisions in all of these? It was physicians. When managed care first came upon us, physicians were concerned that they could find themselves stuck in a managed care plan and not be able to get out when the plan was making them do the wrong things. So they insisted on this, but it can come back to bite them, because I'm advocating for my patient and I'm being, I'm causing all kinds of grief to the health plan. Guess what, doctor? You're out of the network. And again, may not be able to practice, or certainly not practice successfully. So there are 3 jurisdictions by judicial decision. One of them, the leader, is New Hampshire in the Harper case, that said, if a physician has been terminated without cause and maintains, reasonably convincingly that no, the real reason was that she was an advocate for her patients, the physician has the right to judicial review, and that termination will be reversed as a matter of public policy. Okay. These are the states that have done this by both by decision. In New Hampshire, you see Harper versus HealthSource, and also in a few states by law. Before terminating a contract, the health maintenance organization shall provide the physician with a written explanation of the reasons. That's not quite far enough, because they also need, the physician needs to contest that termination in appropriate circumstances. So we need all jurisdictions to adopt the principle that if the doctor can show that she was being punished for being an advocate for her patients, she can't be terminated without cause. She can at least seek judicial review of that. And then, of course, more straightforwardly, we need to have the courts or state legislatures pass laws that prohibit health plans or employers from, in any other way, penalizing physicians for advocating for their patients. And there are a number of states that have this. Here's Idaho's code. A managed care organization shall permit a contracting provider to advocate for his patient without being subject to termination or penalty for the sole reason of such advocacy. Okay, so again, we need to have this in all the states, the gray ones as well as the red ones. And how good can these protections be, right? Termination or penalty, what counts as a penalty? My thought is that what we should give doctors is the equivalent of whistleblower protection. And that is that is the highest degree of legal protection to someone in a relationship in which they might be subject to adverse, actions, short of putting them in a witness protection program. And these are the types of behavior by, for example, a health plan or employer that are prohibited for people against people who have whistleblower protection. Whistleblowers, historically, they're people who blow the whistle on somebody to the government. But all doctors should have whistleblower protection when they're advocating for their patients, right? No threats, no intimidation. Don't, close the coffee machine, whatever. Okay. And what about enabling patients and their doctors to go further and punish the plan if it starts doing this, or if it is imposing unreasonable incentives on doctors? Shouldn't the victims, or the ones who are kind of caught in the middle, the doctors, be able to sue for aiding and abetting a breach of fiduciary duty. There is such a precedent in the law. There is a cause of action for aiding and abetting a breach of fiduciary duty. There are cases, mostly commercial cases, a famous one from Connecticut in 2008, where somebody, successfully, you can sue if some defendant has kind of encouraged a breach of fiduciary duty by someone else against you. The problem with that is, one advantage, if there was that ability, was that doctors being sort of badgered by an employer or a health plan to do the wrong thing for the patient. You say, wait a minute now, if I did the wrong thing, that patient can sue us for aiding and abetting a breach of fiduciary duty. So I'm protecting you, health plan, you hospital employer, by doing what's right for the patient. The problem is that in order for the patient to bring that suit, there has to be a breach. And what we want is to protect the doctor when she avoids the breach. So what we really need is a cause of action, and I don't think there is one, attempting to induce a breach of fiduciary duty. And that's something interesting to think about. There was another twist in the Wickline case. Dr. Polonsky, the doctor, testified on his own behalf that had his Wickline, his patient's condition, in his judgment, been critical or in a deteriorating condition when he discharged her, he would have made some effort to keep her in the hospital beyond that day, even if denied authority by Medi-Cal. And here's the interesting thing: even if he had to pay her hospital bill himself. Is that what he has to do to fulfill his fiduciary duty? Is that what his fiduciary duty requires? How does he know? How does he know? So it might be useful, and Professor Markovich talked about having, fleshing out this notion of fidelity with some more concrete ethical principles, and the AMA, ethics opinions do so to some extent. For example, talking about how doctors, are in a compromised position when they enroll their own patients in research and get paid $5,000 a head for that. But how about some place that the doctor can go to get advice? I've got this patient, I think she should stay in 8 days. The plan is not approving that. Do I have to pay for her myself? And have some expert body somewhere that could provide some advice. And if the doctor follows that advice, even if bad things happen, then at least she has a sort of a presumptive argument. The burden would then shift to the other side to say, well, you still breached your duty of law. Final case is a case from Nebraska, Murray versus Nebraska Medical Center. This was a patient with acute pulmonary hypertension, which causes heart failure. The doctors wanted to order a drug for her called Flolan. That was actually approved by the FDA only for the chronic version of this condition. She had an acute version of it, but it was the only possible drug that could help her. They first sought a prior authorization from the patient's health plan. And by the way, going back to our historical overview, what an important change that happened starting with the growth of managed care was a shift from retrospective utilization review to prospective utilization review. So what used to happen is that the doctor would treat the patient, bill the patient, or bill the patient's insurer. The insurer would then decide whether or not the care the patient received was medically necessary or not. And they might deny payment of the claim. But guess what? The patient had gotten the treatment. She's still alive. Prior authorization was the method that increasingly managed care came upon, which is, before the patient gets the care, we're going to have to give our permission, which raises the threat the patient won't get medically necessary care. So the doctors at the Nebraska Health Center asked for prior authorization. It was important to get it, not only to start the drug, but to get some sense that she could continue on it, because once you're started on Flolan, if it's discontinued, you die. Fatal, just like that. And furthermore, that drug at that time cost $100,000 a year. So patients not going to be able to pay that. We have to make sure that there's some third-party payment. The doctors sought prior authorization on June 29th, 2006. It's unclear from the case if they ever received it, but in any event, they hadn't started the medication when 11 days later, the patient went to the emergency room and died. The patient's family sued for malpractice for not starting the drug earlier. And the court held that it was within the standard of care to wait for the insurance approval, because if they had started the drug and they didn't get the approval, they would withdraw the drug and the patient would die. Kill your patient by telling them. So Supreme Court of Nebraska got that wrong. But the interesting thing in that case, to me, is that there's no indication that the doctors did anything besides wait to hear back from the plan. They filed a request for prior authorization, they waited, and 11 days later, they hadn't heard, or they didn't, act on it, and the patient died. Should they have done anything more? Would they have done anything more? Sure, they could have pestered the insurer, right? Don't just sit on, just to sit back for 8 days, 11 days. Bug them, call them once a day, call them 10 times a day, right? Have you made a decision yet? Have you made a decision yet? They apparently didn't do that. They work for a not-for-profit hospital system. Ask the hospital to cover the care, at least initially, as part of its community benefit obligation under the tax laws. Ask the drug company for a compassionate IND, right? Give it to my patient less expensively, or perhaps even free, because it's life sustaining. But they didn't do that, okay? And raises the question of not only did they commit malpractice, but in failing to do that, weren't they also breaching their fiduciary duty to the patient? But there's another point I want to make about the Morty case, and that is, as Dr. Frizoff will remember, he invited me to give a talk to a bunch of progressive primary care physicians in Cleveland, a house talk. And I talked about this case, and I went through the same thing I just did now, asking them, what could you have done what could those doctors have done instead of sitting on their hands and letting the patient die? And there wasn't much answer to that, so I gave my answers, the one I just gave. And one of the members of the audience raised her hand and she said, "You don't understand, Professor Millman. We don't have time to do that. We don't have the ability to do that kind of advocacy for our patients because of the pressures, time pressures. We have to see 20 patients, whatever, half a day. We don't have the time to do that. So we need to facilitate the ability of physicians to advocate for their patients. One way, perhaps, is Dr. Batanti's billing code. If they get paid for it, maybe they can say to their hospital employer, this is earning money too. You talked about the present, how they have to rely on so much of their staff to help file disputes in medical necessity determinations. I'm curious what kinds of people are doing this process for the doctors. What is their background? What is their training? Are they trained to be advocates for their patients? I doubt it. I think they're more like, office people, billing people, and so on. So it would be good if we had a cadre of health professionals who were trained to be advocates for their patients and could assist the doctors in doing this. And the doctor would provide the medical rationale to this person, let's call them a medical advocate. And that medical advocate will be trained in how do you fight the insurance company? How do you get an external review? Know the steps and know how to do it and take the responsibility for doing it. And you have medical advocate, a fiduciary duty to that patient as well as the doctor. So I gave a talk about this a number of years ago at Widener in Philadelphia. And afterwards, a bunch of people in the audience came up to me and they said, we graduated from Sarah Lawrence, where we have a master's in patient advocacy. And, this already exists. They're patient advocates. The hospitals have patient advocates. And I said, okay, so you're a patient advocate and you're working at a hospital. You encounter a patient clearly has been mistreated. Do you feel able to say to that patient, you need to hire a lawyer and sue the hospital? And they said, I can't do that. So that's not what I'm talking about. I'm not talking about patient advocates. I'm talking about, we actually have a set of professionals. They're independent patient advocates, but they are paid by patients, and not every patient can afford that. They're great at what they do, but we need to have a cadre of health professionals assisting physicians, helping them to do the right thing, who are not paid by the patient, but are paid by health plans, the government, accountable care organizations who have medical teams have to have one of these people as a member of their team, and so forth. So one idea is perhaps a new training program is needed. Maybe the independent medical advocate training programs are adequate. I don't know enough about them. I want to look into them more. And an interesting question is who certifies them. Right now, there is an entity called the PAC Board, which certifies independent patient advocates, but they also certify the patient advocate who can't tell the patient to sue the hospital. And I just wonder, how good are they at preparing patient advocates to do the right thing, when push comes to shove. So a number of ways, I think, in which the law can take a role in helping physicians to be able to be advocates for their patients, rather than thinking about punishing the physicians who don't do the right thing. Let's think about how can we support and encourage physicians to do the right thing. Can law help save medicine? Thank you. It's kind of late. I'm sure we're all kind of tired. One of the things we had originally saved a chunk of time for here was other ideas, because there are lots of people both participating remotely and listening who probably have all kinds of additional good ways that we can move forward in this direction, assuming, I hope, that we all agree that it's a good direction to move forward in. I think what I'd like to do, though, just unless people have strong objections, is to table that discussion till tomorrow, when we can reconvene, I believe at 9 o'clock. I have to look at my schedule. And talk about, additional good ideas. Yes, 9 o'clock, breakfast from 8 to 8:45 as it was today. Talk about any additional good ideas that anybody would like to throw out. And then, where do we go from here? Very nice having a talk with you. But as we told medical students, don't stop here. So how can we keep going? All right, so with your permission, I will, is anybody outside who, no, okay, so anybody have any comments or thoughts, by the way, on my talk? Oh, yes, Dr. Batani.
Professor, I love the idea of medical advocacy, but I think it goes back to when that physician at Dr. Freisoff's event, when they told you we don't have the time to do it. I think they probably left off the second half of the statement is we don't have time to do this for free.
We're not getting paid for it. Yeah.
So, whether you have another trained individual to do the advocacy, there still needs a mechanism for that to be paid for. And that's independent from taking care of the patient.
Right. So your billing code would be accessible to the medical advocate as well as the physician, right? They would be able to bill for that, for those services as well. Just like, as somebody mentioned earlier, doctors, never used to have, rarely had end of life decision-making conversations with hospitalized terminal patients because there was no billing code for it. And when Medicare a few years ago instituted for the first time a billing code for that, those conversations began to flourish, and they're critical to patients and their families. So a great idea, but let's make the medical advocates also able to bill under that, or incident to or some other configuration. Let's have the doctors fulfill their advocacy, their advocacy responsibilities, but let's help them do it. Let's protect them when they do it. Let's give them the resources to do it as well. All right.
Professor?
Yes.
In California, we have two anti-retaliation statutes. One, business and profession code, the other one, the health and safety code. The problem is that the penalties for violating those are so anemic that they count for nothing. I think the penalty for retaliating against a physician is like $500 or some ridiculous thing like that. And people say, well, how much do you think it should be? I said, well, this is a public safety issue, the same as when a health group of doctors don't report one of their own that have been settled out for more than the reporting requirements of the medical board is $100,000 fine.
Failing to report a colleague for medical malpractice.
Right. So why $500 against somebody for retaliating? The other thing was in the health and safety code, it's equally as anemic. And I think both of those should have hefty fines as well as statutory attorney fees.
One of the things that our postdoc, Rebecca Smith, helped research for me was looking into what are the penalties for violating those state laws that I described for you. And again, they're very, very weak and very restrictive. All right. Without more than thank you all very much. Those of you who are joining us for dinner, dinner is at 6:30. It's nearby. It's a block from the law school, but more importantly from the Glidden House. So what I'd like to do is I will meet you at the entrance to the Glidden House at about 6:26 and walk you over to the Tinkerville Student Center where the Michelson Worley restaurant is located, where we will be okay, so between now and then, enjoy the University Circle area. I hope it's not snowing out there. And dress for dinner, by the way, doesn't have to be formal. I suggested they had bubbles. So no, you probably have to have one. All right, any questions? Well, then, thank you very much. Thank you for the people who are participating remotely. Thank you for our remote experts and our present experts. And I'll see you all tomorrow morning.
Ouch.